5 more minutes? Would you like me to do a little intro?
Sure.
Okay. I'm not going to be able to really give a bio on you because I don't know enough about you, but tonight's Tom has graciously agreed to do a workshop for us on understanding Connecticut's Freedom of Information Act. It is complicated. It's a huge topic, but there are perennial questions that keep coming up. So we have compiled a list of questions that people sent in and things that we could think of. But Tom's going to do his presentation. And if he hasn't addressed those things at any of your questions at the very end, he'd like you to ask them. But also as we go along, I'm sure he's going to tell you how he'd like you to do that.
Right.
So.
And what we'll do is we'll ask you to stay muted while I'm talking. But if you've got a question as we're going along, just raise your hand, and Sherry's going to be the moderator, as it were, and she'll let you in. Sherry and all you folks, thanks so much for the invitation. We love doing these workshops. You know, I only wish circumstances were such that we could come out and be with you in person, but we'll make it work this way. It's a little like talking to Hollywood squares, you know, this square, that square. But we've, in the last couple of years, I've learned how to do it. I'm not technologically brilliant, but we'll make it work. Apologies in advance for any barking dogs that you might hear. We not only have our own, our daughter has left hers while she goes on a little trip to faraway places. So sometimes they get rambunctious. So if you hear them, you'll know what that's about. For those of you who don't know me, I am the Public Education Officer at the Freedom of Information Commission. And in that role, I do these workshops all over the state. I was teasing with a couple of the folks from Hampton that, you know, they're one of the 10 towns where I haven't been, but Rose reminded me that I've done one for the Board of Ed. So you're off the hook, Rose. We've been to Hampton. And we do them not to beat you up, not to make you miserable, but to really try to help, to try to answer your questions, to try to make it so that if you have to deal with an issue that concerns freedom of information, you're better informed, you're better equipped, you've got the tools to work with, so that if FOI becomes an issue, you're comfortable working with it, dealing with it. A little bit about me, just so you know, I'm not an attorney. I often ask if that's good news or bad news. I don't know how you feel about that, but the reason I share that is that I'm not able to give you any binding legal opinions. These are not orders from the commission. These are not commands. This is advice that I'm able to give out. I've been doing this for more than 21 years, and it's based on, you know, my study of the FOI Act, my conversations with our attorneys, my observations of what our commission has done, decisions that they've made. And again, it's just advice based on my knowledge and what I think our commission would tell you to do under certain circumstances. I also like to share with you that I understand what some of you have to deal with on a regular basis. Being on a board or commission is not always easy. It's not always fun. You have your life during the day, and then you've got to come home and wolf down a dinner and go to a meeting. But I get that too. I was a member of one board in my town for 10 years. I was its chairman for the last 5. I filled out an unexpired term on the Board of Selectmen a couple of years ago. I did that for 2 years, and I recently was asked, and for some reason said yes. I'm not quite sure why. If you guys can explain that to me, I'll be happy to take your advice on that. But I'm on another board that meets, you know, again, on a regular basis. So I know what it's like. And a lot of times when I go out and do these workshops, especially at night, people say, hey, Tom, you don't get it. You don't get it. We're volunteers. We didn't sign up for this FOI stuff. Well, as you can imagine, I do get it. My board happened to have somebody who knew a little bit about the law, who could guide them through some of the pitfalls. But most times when you go to a board or commission and you're either elected or you're appointed to serve, you don't have anybody like that. So that's why these conversations can be good. When we talk about freedom of information, I want to remind you that it's not just some really cool idea. It's the law in the state of Connecticut. It's a law that has been in place for 47 years. It was Ella Grasso's brainchild when she ran for governor for the first time. And if you do the math, 47 years ago puts us right smack in the middle of Watergate. and you had a country that was in turmoil, a country that was upset, a country that was beside itself, nearing a constitutional crisis, many felt primarily because things were being done in secret, things being done behind closed doors. And Ella Grasso was in Congress when Watergate kind of exploded, if you will, all around us. And she was contemplating her run for governor in 1974. And she said, you know, if I run and win, one of the first things we're going to need to do is create some sort of an open government law so that what I'm watching here in Washington doesn't happen in my state. So as you know, she ran and won. And in 1975, when she took office, this was one of the first things that she did. She put forward the concept of an open government law. And she felt that it was really important. And not only did she keep her campaign promise, she did something that was kind of interesting. And those of you who are, who study or watch politics might get a kick out of this. She says, you know, this law is so important to our state, I will see to it that it is approved unanimously by our legislature. Have any of you ever watched the legislature? Right? Can you imagine guaranteeing a unanimous vote on this law or on anything? Well, I'm here to tell you that she guaranteed it and she got it. I've seen a video. I've seen an actual video of the vote. There wasn't a single no vote in the House, not a single no vote in the Senate. This law passed unanimously. Now, why do I share that with you? Well, it's interesting, first of all, and it shows you how important the law was back then and today. But it also gives you a little insight as to why we have to have these kinds of conversations. Think about getting to the point where you've got an entire legislature to vote yes on a bill. And this bill wasn't necessarily something that was, in the mainstream. This was something that she had to push. Well, of course, to get to the point where everybody voted yes, as you can imagine, there was a lot of negotiation, a lot of arm twisting. And Sherry made reference to what I'm about to say. To get to the point where everybody voted yes, you had to have a lot of compromise. And so you've got a law that's based on a simple, easy concept. But when you start to read it, when you start to dig in, it gets complicated, because what they did was they put the basic concept, open, accessible government, on the table. And then they left a lot open to interpretation. And who gets to do that? Us, those of us who are on the front lines. So you have to have the tools to work with to make the right call. Well, why do you need to make the right call? Because, as I said, it's the law. And the law also created the Freedom of Information Commission, which is where I work. And that commission is where people go when they believe they've been denied the rights that this law gives them. And they file formal complaints against boards of education, against boards of finance, against boards of selectmen, against first selectmen, and saying, we were denied the rights that this law gives us. That's where you don't want to be. You don't want to be the respondent in a complaint brought by someone who believes you violated FOI. So our goal is to put you in a position where you have the tools to work with so that you make the right call. Now, having said that, I quickly add that you could make every conceivable right decision and make the right call, and somebody could still file a complaint. And I don't want you to despair if that ever happens, because they're able to, the other side, if you will, is able to interpret the law the same way you are, and they might disagree with your interpretation and file a complaint. But what I'm going to tell you is that if you have done the right thing, if you have worked it properly and know what you're doing, make the right interpretation, even if you have to go through the process of having a hearing and going through a complaint hearing, the complaint will be dismissed because you've done the right thing. And that's the goal here, to put you in a position so that even if you are the respondent in the complaint, you're able to come out on top, if you will. And also, frankly, you're able to show your constituents that you are about being open and accessible, which ultimately is what this law is meant to do. It's meant to make sure that our public agencies are open, accessible, transparent, so that it's clear that you're doing the work of the people which you were appointed or elected to do. The law is called Freedom of Information, but I always say it probably would be better served to be called Freedom of Access, except, let's face it, Freedom of Information sounds better. But the law is about two basic things. It's about access to public meetings and access to public records. And in a minute, I'll go through some of the provisions, show you some of the ins and outs. I'm going to stick pretty heavily to the meetings provisions, since most of you are volunteer members of boards. I'll hit on the records provisions just a little bit at the end, but if, again, as Sherry mentioned, I'll say it again, if there's anything that I don't touch on, Sherry sent me a nice list of questions, many of which, the answers to which are woven into the talk. But if I don't hit on an issue or I'm not specific enough, please stop, ask the question, and we'll try to get an answer. And by the way, I'm not afraid to say I don't know if it's a question that I don't know the answer to, but I'll ask you to send me an email or call me at the office and I'll get you an answer. Again, it's not an order or a command, it's just advice, but it'll at least give you something upon which to make a basis upon which to make a decision.
Tom, before you go from here,
Yep.
do you want people using the chat box if they have questions?
If I can figure out how to use it, sure. That's no problem.
If I'm happy to read the questions if you know, if
John,
people
that's
put them
perfect.
in
John, that's
chat.
great.
Thank you, John.
So John, if you see one, just say, hey, Tom, we've got a question, and
Sure.
you go ahead and read it. That's great.
Of course.
Okay. So one of the places that I start is to tell folks, look, a lot of people think that freedom of information is about free information. They don't understand that it's about access. So people see freedom of information and they look at that as an invitation to walk into a board meeting or to walk into a town clerk's office or a first selectman's office and start asking questions. I don't know if any of you had experienced that. I suspect, Sherry, you have, some of you others probably as well. Under freedom of information, I have a right to know. You need to tell me. Well, you may have a right to know, but we have to educate everybody that it's not about asking questions. We're public servants. Look, we're going to answer questions. That's what, we'll do it. But at some point, the question you may not be comfortable answering, or it may be a question that, you better come to the meeting when they talk about it. I'm not in a position to answer it. But a lot of people get sort of, they're insistent that you have to answer their questions. Well, lesson number one, it's not about answering questions. And just to show you about the question answering part, think about working at the Freedom of Information Commission. People see that, they think we're the information center for the entire state of Connecticut. People call us up and send us emails with the kinds of questions that, you just might not believe it. First of all, they think that we sit in this giant vault surrounded by every record held by every public agency in the state of Connecticut. And they ask us to send them things. And we have to say, no, you've got to go to the town or the state agency that has the records. But then they call and they ask questions. I've had people call and ask me for directions. I've had people call and ask me how to get tickets to that night's UConn basketball game. I kid you not, they think it's about free information. So if you've ever had that happen, you have to sort of guide people to understand that it's not about free information. But we do the best we can. Access to meetings and access to records. I don't read a lot of definitions, but I'm going to read the definition of a meeting, and I want you to sort of listen to the words. Meeting means any hearing or other proceeding of a public agency, any convening or assembly of a quorum of a multi-member public agency, and any communication by or to a quorum of a multi-member public agency, whether in person or by means of electronic equipment, to discuss or act upon a matter over which the public agency has supervision, control, jurisdiction, or advisory power. The bottom line is, folks, those of you who are on boards and commissions, is that any time you gather to do your assigned task, to do your work, you need to consider it a meeting and make sure it's open to the public. Make sure that there's an agenda that's been posted that tells people what's going to happen, that it's properly noticed, and make sure that there are minutes in the meeting when the meeting is done. A lot of times people, I get questions like this. Well, Tom, we got a lot of important stuff and some of it's kind of sensitive. Can we have a sort of a off the record meeting? No, you can't do that. I understand that when we come from the private sector, that's the way we do it at the bank. That's the way we do it at the insurance company. But when you're in a public agency, when you're serving the public, the laws are different. The rules are different. You have to do your work in public. Now we'll see down the road, there's ways that you can, exclude the public in certain situations, but generally think about doing your work in public. Well, what if I heard the word quorum in the definition. What if we put together a little subcommittee and the subcommittee is not a quorum of the full board, and then we have the subcommittee do all the work and bring it to the full board? That doesn't work either. The law applies to all public agencies in the state of Connecticut. I won't read you the definition of a public agency, it's pretty long, but there's a phrase in there that goes like this, including any committee of or created by. So if your board creates a subcommittee of even 2 people and gives it a formal task, that subcommittee has to do its work in public. Think of doing your work in public. The meeting's noticed, it's open to the public, and there are minutes when the meeting is done. The law gives us three different kinds of meetings to work with: a regular meeting, a special meeting, and an emergency meeting. Regular meeting is a meeting that you have per schedule. I suspect, we're halfway through the year. Most of you are on boards. You submit a schedule at the beginning of the year. We meet on the first and third Tuesday, the second and fourth Wednesday, 7 o'clock town hall, 8 o'clock library, whatever that is, that becomes your regular meeting time. Special meeting is a meeting that you have when it's not at your regular place and time. A lot of people see that word special and they get all worked up and they say, wait a minute, we can't do this, we can't do that. You can do anything you want to do at a special meeting. Here's the difference. For both the regular and a special meeting, you need to prepare an agenda. I suspect some of you have that lovely responsibility. One of the things that is key with agenda is specificity. The FOI Commission and more specifically the courts have come down pretty hard on boards that have put out agendas that are not specific enough. So agenda specificity is key. Now, I don't know about you, but I cut and paste when I do an agenda. And so an item like other business, old business, new business, got to be honest, that's not a great agenda item. But at a regular meeting, if it's on the agenda, the chairman can say, is there any other business? And a member can say, yes, Mr. Chairman, I'd like to add this. Someone makes a motion, it's seconded, you can add it to the agenda. At a special meeting, you cannot add anything to the agenda. That's the fundamental difference between the two. So if you're preparing an agenda for a special meeting, make sure that everything you're going to discuss is on there. Because if it's not, you can't add it. That's the difference between the two. Otherwise, the meetings are virtually the same. That agenda needs to be prepared, it needs to be available 24 hours in advance, and then you're all set to go. The third meeting, the emergency meeting, is a meeting that I always discourage boards and commissions, especially on the local level, from using. An emergency meeting is meant for an emergency, and in writing the law, the legislature set the bar very high. What you and I think might be an emergency probably doesn't rise to that level in the eyes of the law. The example that I like to use is this. We have some holidays in Connecticut where they're celebrated in some towns, not in others. I'm thinking, Columbus Day, Veterans Day, even Martin Luther King's Day, and some. And I guarantee you it's happened every year in the 21 years that I've been doing this. Somebody somewhere from some town calls and says, Tom, I've got a problem. What's the problem? Our regular meeting is tonight, the night after one of those holidays where the town hall might be closed. I forgot town hall was closed yesterday because we work on that holiday. I forgot town hall was closed. I forgot to bring the agenda down before. I went to town hall, it was closed. So I brought it in this morning. Is that okay? Well, remember what I just said. It's 24 hours before the meeting, and the morning of is not 24 hours. And I say, no, it's not okay. You need 24 hours. And they say, well, we've got way too much to do. And think about your board experience. Every agenda is probably packed. We've got way too much to do. I'm going to call tonight an emergency meeting. I always, always, always suggest that they don't do that, that they forget that idea, because oops, I forgot is not an emergency. In our minds, especially if we're not legally trained, it sure may feel like it. But for the purposes of FOI, unless it's a true emergency, and I mean keeping people safe, keeping people out of harm's way, preventing some kind of a disaster, skip the emergency meeting and have a special meeting. All you need is 24 hours notice. Notice it for 24 hours hence, and you should be okay. If you ever have a situation where you've got an emergency, a big storm is coming or something like that, you've got to prepare. You have the meeting, you talk about only the emergency situation, and within 24 hours within 72 hours, you create minutes that reflect what happened at the meeting, who was there, and what you did about it. But again, that third kind of a meeting is a meeting that I always, always try to discourage you from using. Now, I would just sort of remind you that your meetings are open to the public, that anybody can come. I know we've got mixed towns here, which is kind of neat. But you're at an Ashford P&Z meeting and someone from Thompson wanders in. You can't say, hey, you're from Thompson. What are you doing here? Get out. Anybody can come to anybody's meeting. Anybody can audio or videotape a meeting. It's not as much a deal as it used to be because many boards record their meetings now anyway. But here's something that it comes up a lot. People don't realize it. Public speaking is not something that's guaranteed under the FOI Act. So if you have public comment on your agenda, that's fine. Or even without it, if you want to hear from people when a subject comes up, you can do it. But it's never required under FOI. So let's suppose you have it on your agenda and you look out and the house is packed and you want to limit it because you're afraid you'll never get your work done. You can certainly do that. We only have 2 minutes tonight. We only have 3 minutes tonight. That is in the hands of the board. So you can have that kind of a control. I talked to a woman today who was upset. She said, she was on this meeting and she knew there was a 3 minute, but she asked a question, she said, that the board didn't like and they shut her down. Now that's horrible public policy. That's certainly unfair. We can think of all the words. It may be, a constitutional problem, the right to free speech, but it's not violating the Connecticut FOI Act. So file that away and understand that the public speaking is in the hands of the board. Now, I'm just going to sort of deviate a little bit from the usual script here because we've got a new player when it comes to public speaking and the notice issues, and that's the electronic meeting. When we go back, we're doing it that way tonight, but when we go back pre-March 2020, all your meetings had to be in person. Everybody had to be in the room. Board members could still call in, but the public didn't have any extra access. Then the pandemic hit and the governor issued his executive orders, which allowed us to meet virtually and keep the wheels of government moving. Then the legislature took it up last year and put some provisions in place. And then this year you added a couple small tweaks so that now we have the option. If you're on a board or commission, you have the right to meet in person. You have the right to meet totally virtually. You also have the right to put together something that's called a hybrid meeting, which means you can have a little bit of both. There's some new rules that go together with that, though, if you're going to take advantage of that. And to me, the biggest one is that if you're going to have an electronic component for a regular meeting, either totally electronic or partially, you have to get notice out to everybody that you're going to do this at least 48 hours in advance. I told you 24 hours for the agenda, that still holds, but 48 hours in advance is sort of a notice, a warning, if you will. Hey, folks, P&Z tomorrow night is going to be virtual or it's going to be hybrid. Then the agenda that comes out 24 hours in advance, you need to make sure that that not only is it available, that it's posted on your website. And that website posting also has a link so that people can click in and join your Zoom conference or WebEx or whatever else it is you're doing. And that agenda still needs to be available in your office and online. And it's got to be widely accessible to anybody so that they can click in and get the meeting. You also have to be aware that if it's a regular meeting, it needs to be recorded. And the recording needs to be available within 7 days of your meeting, and it needs to be up on your website for at least 45 days. Interestingly enough, when the legislature put this together, they didn't include a provision for special meetings to be recorded. And I'm puzzled by that, but most people are recording both of them anyway. But if you don't record a special meeting, you would not be in violation of the law, at least as it stands now. And I suspect they're going to mess around with this law for several years going forward. But right now, what I just told you is entirely accurate. Special meetings, the recording isn't required. Another thing to remember with the electronic component, if you're going to have that kind of a meeting, a lot of people have taken advantage of it. People who might not otherwise join in on a meeting. I don't know what you found in your towns, but many towns have found that more people are joining in because they don't have to leave their house. They can sit, in their living room or in their dining room, wherever their computer happens to be, and watch the meeting. But that's also created a situation, and I don't know if that's happened in any of your towns. If I say Zoom bombing, has that happened to any of you? Have you had a situation where people have jumped in? Yeah, I see a couple heads nodding. I'll tell you folks, that was one of the first big problems in 2020. And the issue is not so much that it happened, but that the people were doing it to disrupt the meeting. They were rude, they were arrogant. And I'll tell you what they were doing is that they were yelling racial epithets, they were yelling insults at the board members. And I dealt with a case a month or so ago out of Bristol. They had a situation where their P&Z meeting was interrupted by pornography. And they got so upset, that they involved the law enforcement. And here's the weird thing. It wasn't any of their neighbors. It was some kid in Maryland. So the Zoom bombing that goes on, it may not be people you think it is, but it's very disruptive. The
Tom,
reason
we actually had that happen with the Board of Ed.
Okay.
So a lot of the people who are on here tonight are
They know what
familiar
I'm
with that,
talking
and it
about.
was pornography.
Yeah.
Yeah.
Not cool. And the
No,
thing
and
is,
there were kids who were on.
of course,
Yeah.
of course, yeah. And the thing is, I bring this up because you need to know that you don't have to stand for it. The bottom line is that if you get Zoom bombed, if you get that sort of thing, I'm telling you that you have to make sure that everybody has access, and you've put the link out there and all of that. Yes, you do, but you have a right to run an orderly meeting. And if that happens, you also have the right to kick those people off. Whether they be your neighbors or not, you have a right to shut them down and kick them off to make sure that you can get your work done and that you can, conduct business in an orderly fashion. The right to link in does not give people a right to disrupt the meeting. And by the way, if you go back to in-person meetings, there's also a provision there. If you have people that are rabble-rousing and disrupting your meeting to the point that you can't work, you can have them removed from an in-person meeting as well. Let me share you you'll get a kick out of this maybe. I have one Zoom bomb story to share with you that's happened to me in the 2 years plus that we've been doing this. So I'm talking to a screen very similar to what I'm doing tonight, and a bunch of nice people. It was like a League of Women Voters group over in the other part of the state, and we're having a nice conversation. And all of a sudden, the screen in front of me goes black, and I start hearing all this sort of loud kind of reggae type music. Now, I should add that at the time, my oldest daughter, who was an international teacher, was teaching her first graders. You can see that maybe a banister over my shoulder here downstairs. She was teaching her first graders in Panama from my house. And so I thought that the music was coming from her first grade. Then all of a sudden she yells up the stairs and says, "Dad, what's that music?" And I'm thinking, uh-oh. And just as she says that, the strippers parade in front of my eyes, right in front of, as I'm trying. So here I am talking about FOI, and here come the strippers. Fortunately, they had someone like John who was able to get them off quickly. Needless to say, that was somewhat startling to see that. And they didn't leave a lot to the imagination. Let's just leave it at that. So those are the sort of things that you do not have to put up with. You have a right to stop it immediately and run an orderly meeting. There's one other little piece of the electronic meeting that I get. Hasn't come up yet, but the legislature put a provision in there that if somebody gives you a request in writing at least 24 hours in advance, it says, "Hey, I don't have internet access, or I can't, this is a regular meeting. I have a right to attend it, but I can't do it because I don't have the technology." You would have to find a place for that person to sit and watch the meeting, be it in town hall or a library or a school building or something like that. I've had no calls on that yet, but that's a little provision that they threw in there as well. So just sort of keep an eye on those kind of things as we go forward, and keep an eye on the legislature. I suspect that they'll tweak and work with this, because this is new for all of us, having these meetings done virtually or in a hybrid fashion. One other thing that's come up is, when you're on a board, let's suppose the meeting's in person, and one of the board members is on vacation but still wants to participate. Board members can always sign in. Board members can always participate virtually. That doesn't mean that you would have to give that same right, I guess, or the same opportunity to everybody else. If your meeting is in person, a board member can call in without it becoming, an electronic or a hybrid meeting. Now, we talk about the different kinds of meetings. We talk about being open and accessible, making sure that the public can sort of observe. There are two different paths that boards and commissions can use to exclude the public. One of them, I suspect you're all familiar with, is called going into executive session. Now remember, to go into executive session, you need to remember that it's still part of an open meeting. So even if the only item you have on a particular evening is an executive session item, you still need to notice the meeting, convene in public, then someone needs to make a motion to go into that executive session. And you go into that executive session, you need a 2/3 vote to do it. And I should have mentioned this before, when we talked about adding items to the agenda, that also requires a 2/3 vote. Then you want to make sure that when you go into executive session, you articulate very carefully the reason for the executive session, that it should be on the agenda. It should obviously be in the motion as well. You go in, 2/3 vote, you have the conversation you're going to have. You talk as long as you want, then you make sure you come out of executive session to vote. You must always vote in public. The vote needs to be in a public forum. It needs to be recorded and included in the minutes. So let's suppose we've got that one item executive session meeting. Madam Chairman, I move we go into executive session. Second, 2/3, you state the reason, you go in, you talk, and then you come out and the minutes reflect any action you would take it. There's 5 reasons for an executive session, and they're pretty narrowly construed. So you want to be careful and make sure you don't sort of overstep. The first one, a personnel matter. Now, when we talk about a personnel matter, we talk about a couple of things. We make sure that we understand that just putting personnel matter on the agenda, or just putting I move we go into executive session for a personnel matter, that's not all you do, because the law says you need to have more than that. You need to not necessarily name the person, but you have to have something like executive session plan, discussion of the performance of a public works employee. Your Board of Ed folks, discussion of the performance of an administrator, discussion of the performance of a coach, discussion of the performance of a teacher. Then you have to make sure that you notify that individual in advance, that that person is given advance notice that he or she is going to be discussed in an executive session. And then the person has the right to come forward and say, no, wait a minute. I don't want you to talk about me in executive session. I want that conversation to be in public. I want everybody to hear it. And if the person says that, you cannot go into executive session. You must do the entire conversation in public. Now, where the person gets confused is the person thinks, oh, wait a minute. I don't want it in public, but damn it, if they're going to talk about me, I get to be in the room, right? And intuitively, that makes a lot of sense, but the law doesn't give you that right. Once you waive that right to have the discussion in public, whether or not you're in the room during the discussion is entirely up to the board. Now, the board frequently invites the individual in. Typically, they want to hear from the individual, but it's not required. So just sort of file that away. You have a right, the person has a right, or you, if you're the individual, to demand that it be done in public. But if it's not, then the rights shift, I guess you could say, back to the board, whether or not they invite the person in. The board can invite in anybody it wants to give evidence, to give testimony, to hear somebody's side of the story. But after they're done gathering all that information, they need to make sure that everybody else is out. The only people who have a legal right to be in the executive session are members of the board. So the board invites people in, and then when that's over, people can go out. They need to go out so that the board can have its discussion. And remember, do not vote behind closed doors. The second reason, pending claims or pending litigation. You've got a lawsuit against you. You've got an FOI complaint. You've got an ethics complaint. There's litigation, and you need to talk about your strategy. The law allows that. The law allows members of boards to go into executive session to talk about legal strategy. It also expands it a little further. It allows boards and commissions to have a conversation about taking legal action. Let's suppose you're on a ZBA and somebody applies for a variance and you deny it on what you feel is solid ground. You deny the variance. The person goes ahead and puts that swimming pool in the yard anyway, and it's too close to his neighbor's backyard. You find out about it and you want to take action. You can't let people just sort of run willy-nilly. You've said no, and they did what they wanted to anyway. So you want to go into executive session to talk about the legal action you're going to take to protect ZBA's rights. You could do that. Again, only discuss action in public. The third reason, a security matter. Security matters, folks, never used to come up a whole lot. And those of you on the Board of Ed will identify with what I'm about to say. But ever since Sandy Hook happened in 2012, it's come up a lot, especially with boards of education. discussion of resource officers, discussion of deployment of security cameras, discussion of escape routes, all those kinds of things that we never used to talk about. That board that I was on for 10 years and chaired for 5 was a board of education. We never talked about stuff like that. We didn't have to. But unfortunately, we're in a different world today. It's horribly sad, but the reality is that boards of ed have to do their best to try to protect their kids. And those, you wouldn't want to have those conversations in a public forum on the off chance that the people you were trying to keep out were sitting out there listening to how you were going to try to keep them out. Another example of a security executive session would be something that's come up a bunch in the last year or so: cybersecurity. I've had several instances where towns or boards of education have been hacked. They've been shut down, and they needed to go into executive session to figure out how to make sure that it doesn't happen again. So again, why would you have that conversation in public when the people who did the hacking might be sitting there listening to your strategy? So you could do that behind closed doors as well. The fourth one, something about a land transaction. You're on a building committee and you're looking for a piece of property to build a new school or a new police station, or you own a piece of property as a town and you're looking to lease it or sell it. Well, you could have those negotiations behind closed doors. You wouldn't have to do those in public and sort of give away, if you will, the town's position. You could do that behind closed doors as well. And the fifth and final reason is a bit of a catch-all. It allows a board or commission to have a conversation about a document or documents that it believes are exempt from disclosure. You've got a document that you're not going to share with the rest of the world. You could talk about its contents behind closed doors. A great example I have comes from my Board of Ed life. You put your transportation contract out to bid, and you get all the bids from all the different companies, DATCO and First Student, and they all come in, and you want to look at them. Well, there's an exemption in the FOI Act for bids and RFPs until you've actually signed the contract. So you put a project out to bid. When the bids come in, you're allowed to withhold them. So in this instance, the Board of Ed would withhold those contracts, those RFPs, bids, wouldn't share them with anybody, then go into executive session and look at the different bid alternates, the pricing for fuel, tires, things like that. Could have that conversation behind closed doors. Another example, you are a board and you seek a written legal opinion from your attorney. You become the client in that instance. The board gives you a written legal opinion. It's covered by the attorney-client privilege. You're not going to share it with anybody. You could have that conversation behind closed doors because you wouldn't want your legal opinion to be well known because you need it to strategize. Folks, remember, you always want to make sure that you only discuss behind closed doors, that you have the conversation. Talk as long as you want. There are no restrictions on time limit, but then you come out of that executive session to vote. You always want to make sure that you've done that properly. Take a pause. Does anybody have any questions about executive session? Sometimes there are questions about executive session. Okay. Seeing none. In addition to executive session, the law has also created a path for boards and commissions to go behind closed doors. It's one of those that I find difficult, sometimes banging my head against the wall to try to describe for people. I read you the definition of a meeting. It says meeting does not include. The next sentence says meeting does not include. And there follows a listing of things, every single one of which all of us on this call would say, gee, that sounds a lot like a meeting. What do you mean meeting does not include? Well, it means that the legislature looked at them and said, you can call them a meeting if you want, but for the purposes of FOI, they're not a meeting, which means that it's not noticed, it's not open to the public, and there are no minutes. The top of the list is collective bargaining. I don't know, do any of your towns have any collective bargaining? I suspect the boards of ed do. Well, when you go into those, those sessions, those collective bargaining sessions, they're not meetings. I don't know about you, but if I've done them and you sit there, what seems like endlessly, and you're going back and forth, it's in a small town like yours, like mine, it's one of the most important things that we do. The whole town budget, the mill rate kind of hangs on the school budget. And yet you're having these negotiations for a big chunk of that school budget, and nobody knows about it because it's not a meeting under Freedom of Information. Executive level search committees. your superintendent of school, your police chief, your public works director is going to resign or retire or move on to another town. Well, you want to form a committee to look for the best possible candidate. You could do that behind closed doors. Now, I think about that one some, and that one makes sense to me. You've got a situation there where you're looking for the best possible candidates, right? And it's in all likelihood, you're going to get applications from people who have jobs, but don't want their current employers to know that they're looking. So that one kind of makes sense. Here's one that I get a kick out of. You're allowed to have a chance meeting or a social meeting, neither planned nor intended for the purpose of discussing matters relating to official business. Well, you guys like each other. You want to go out to dinner after the meeting, or you want to go out for a drink more likely after a meeting. And you go out for a drink, but you can't talk about business. And I laugh at what the heck else are you going to talk about, guys? Come on, let's not be naive. Let's be realistic. Those conversations are going to happen. You're not supposed to have them at all. I'm supposed to sit here and tell you never talk about board business outside of the, well, let's be real. If you guys go out for a meal together or for a drink after a long meeting, you're going to talk about stuff. Here's the advice that I always lay on people. Please avoid the deep, deliberative conversations that you should be having at the table. We can't be so naive to believe that those conversations don't take place, but keep them on a surface level. Keep them on, can you believe what so-and-so said during public comment? What do you want to put on the agenda? What do you want to talk about at the next meeting? I guarantee you the one time you have that deep discussion, that philosophical debate that you should be having at the table, your board table, you're at a restaurant and the person sitting behind you hears it and says, aha, they've had an illegal meeting and files a complaint. I guarantee you that's going to happen. Be really smart the level to which you have those conversations offline. We can't assume that they'll never happen because that would be silly. They're going to happen, but don't conduct your business offline. Do not set your budget over the eggnog at the Christmas party. Be really smart about those kinds of conversations. And to that end, I don't know, back to the beginning, back to the definition, whether in person or by means of electronic equipment. Electronic equipment was written 47 years ago for the chairman who got on the phone and said, I need your vote on this and your vote on this and help me with this and do this, boom, boom, boom. And you walk in, the full house, everybody's in the room. Chairman makes a motion, asks for a motion, motion's made, seconded, boom, boom. What happened? What happened is they had the meeting, they decided everything on the phone before the meeting took place, and you can't do that. You can't have the meeting on the phone. You have to do your work in public. And I know it's not convenient, and I know it can be difficult. Remember, I sat where you sit, but you have to respect the law that wants work done transparently. And today it's about a lot more than telephones. Think about it, emails and texts and Twitter and Facebook and all of those things. I'm not telling you not to use them. That would be foolish. That's the way we communicate today. The chairman has a piece of information, has a newspaper article, has a position paper that he or she wants to share with everybody. By all means, share it with everybody. Hey folks, this is how I feel about this. This is what I want. I want this to go out and I want everybody to read it. That's fine. It's not a problem to send it to everybody. Here's the problem. You send it out, somebody writes back. I think that's the dumbest thing I've ever heard. Then somebody else jumps in and says, no, I really like that idea. And the next thing you know, you're having a debate via email or text. That's a problem. It's a problem on two fronts. One is you're probably having an improper meeting. And two is you've got to remember that those documents, those emails, those texts become public records. And someone could ask to see them. And then you've got a situation on your hand where you've probably had an improper meeting that's uncovered and a position that you hadn't really solidified yet comes out for the public view. So to the extent that you're going to have those communications with each other that way, be smart about it, be careful about it. I'm often asked, well, wait a minute, it doesn't matter. They're my own cell phone. It's my own laptop. Folks, if you create something in the conduct of your town's business, it doesn't matter what device you're using. It becomes by definition a public record. It becomes a public record that anybody could conceivably ask. It doesn't mean that a police officer or someone from FOI is going to come in and snatch your phone or your laptop or remove your desktop. It means that you have to be asked to extract those records that you've created in the conduct of town business on your personal device. So be smart about that. understand that, that it's not illegal or anything, but that those particular records would be exposed if someone wanted to see them. The last thing we should talk about with meetings, before I give you just a tiny bit about records, is minutes. I get a lot of questions about minutes. One of the things to understand is that the FOI Act gives us very little legal guidance on minutes. Technically, the only requirement for minutes, content-wise, is a record of who votes for what or for whom. So my advice on minutes is they need not be the recreation of War and Peace. They are not meant to be every word that everybody says. They are not meant to be verbatim transcripts. They are meant to be documents that capsulize, that give you a crisp, clear, concise recapitulation of what happened, including a record of the votes. They need to be available to the public in 7 days, period, end of story. They are in, the public can see them, and that's it. And the people who do the minutes should be able to move on to the next events. I get a lot of questions about, well, gee, we just draft the minutes. No, minutes need to be available in 7 days. It doesn't matter whether they've been approved or not. Most boards don't meet again in 7 days. Those minutes become the minutes. They are public record. Then people say, well, wait a minute. At the next meeting, we made changes. The preferred methodology is that at the next meeting, those minutes reflect changes that are made, because that first set of minutes becomes a public record that cannot be destroyed, it cannot be removed. So you have those, and then you have the next set. So you can always look at the next set of minutes to see if there are any significant changes. Okay. I see a question. John, help me with this one.
Sure. It says, what if the meeting doesn't have any votes at all? What's required to be put in the minutes?
What would be required is that X board met, members A, B, C, D, and E were there. Topic A and B, topic A was discussed, no action was taken, period, end of story. We adjourned at 8:45, whatever that is. That would be the best way to do it. Minutes, they go all over the place. And by the way, if any of you are minutes takers, I do feel your pain. I do the FOI commission minutes. But again, we try to keep them crisp, clear, concise, and move on. There's a question that was on here. I want to stress something about agendas. Going back to the beginning, I just noticed that there were some agenda questions here. Question about, can you revise an agenda after you file them? The window for the agendas is 24 hours. So you can do anything you need to do with an agenda up to 24 hours in advance. But once you've reached that 24-hour in advance point, you can't change them. At a regular meeting, you can add stuff. You can always eliminate something from an agenda at the meeting. You don't have to take it off in advance. Let's suppose you've got new facts in play and you decide it's an issue you don't want to talk about. So you have to do that. And then back to the minutes thing. What if the minutes don't add up with people's memory or a recording or something that you have? That's up to the board to decide. The board has to look at those and say, you know what, we need to change that or we need to fix that. The recording is not the permanent record, the minutes are the permanent record. So you want to make sure that the minutes are as accurate as they can possibly be. I'm trying to think now, when it comes to meetings, that's pretty much it. Oh, there's another question here about quorum. Two questions about quorums that Sherry sent me. First of all,
Tom, could I interrupt?
Yeah.
So there was another chat question posted.
Sure.
So the question is, do emails sent to a board or to board members need to be included in the minutes?
They do not. Some you can if you want to, but that's not required.
Okay, thank you. All right, you get back to your
So
list.
I'm going to talk just again about, I lost my train of thought, about, where were we? We're talking about quorum. There's nothing in the FOI Act that defines what a quorum is. Now, typically it's, one more than half, but many towns make it higher. And it's really, many towns adhere to what Robert's rule says. That's entirely up to you. And then the question is asked, well, what if we have a meeting, we notice the meeting and no quorum shows up? Well, there's nothing in FOI that says whether or not that's a legal meeting. There's some towns that say no quorum, you got to shut it down. There are other towns that say you can go ahead and talk. We wouldn't have any jurisdiction over that. My advice is if you sit around and talk anyway, make sure that there are minutes that reflect, the board met, there was no quorum, we sat around for an hour and talked about the budget, no action was taken. You should still memorialize the fact that the board, had some kind of a discussion, but again, the minutes need not be long and drawn out.
I'm going to jump in. Jean McCarthy, is that your hand up that you want to have a question? Is that what you're showing us? You're muted.
You're muted, Jean. If you want to unmute.
Still muted.
I was typing a question in chat, so my fingers were going.
Oh, okay.
Okay.
Do you want me to just say the message?
Sure. As long
Why
as you're
don't you
up.
go
Okay.
ahead? You
It was
grab the
about
floor.
executive session.
Yeah.
You said that you have to notify the person that you're going to be discussing an executive session.
Right.
Sometimes there's times when an issue comes up at the last minute and you need to discuss that issue about personnel, but you don't have time to really notify the person. Can you still go into executive session?
I would recommend against it, Jean, because the
Okay.
person could file a complaint. Sometimes it's somebody that's well-known, you can get to them and telling them a couple hours in advance is okay with them. But if
Okay,
it's
so
not,
hours.
if
Okay,
it's at all contentious, I would not do it.
okay, thank you.
You
So,
bet.
Tom, this might be a related question. This is in chat. If you do need to discuss potentially eliminating a staff position due to budget, not performance, and the person in question won't be told that's the case until the board approves the change, what would the agenda say?
Okay, it would say, first of all, that would not be a good cause for executive session, John. That's a tricky question. But if it's only about a position and not the individual in that position and his or her performance, then you'd have to have that discussion in public. Then you wouldn't have to worry about notification. So the budget would say something like discussion of potential staff reduction.
Right. Okay. That's an important distinction. Thank you.
Yep. It looks like Ann has a hand up.
Go ahead.
I have a question about quorum.
Yep.
If the bylaws say a quorum should be regarding the number and majority of the persons present,
Yep.
you have 3 people present.
Right.
Would a quorum amount to 2 people?
Again, FOI doesn't deal with a quorum.
I know.
That's so how many people on the board, Ann?
6.
There's 6 and your bylaws say 3 need to be present?
No, it doesn't say that, just the majority of people present.
The quorum is the majority of those people present. Well, if you wanted to interpret it as 2, that again, FOI wouldn't step in there. That would
Okay.
be more of a local thing. That wouldn't be anything we would have any control over.
Okay, so that would be a quorum then.
It seems odd to me, but if that's the way your bylaws are written, but remember, I'm not a legal mind here. That doesn't sound right to me.
It sounds like a bad idea. Yeah.
Yeah, and I wouldn't do it, but there's nothing in the FOI Act that would stop you from doing it.
Okay,
Okay?
Yep.
So let me give you just a couple of words. I'm mindful of the time. I know you like to, have this chat go on for hours and hours, but we won't do that. Let me just give you a little bit of an insight about public records. I made reference to it when we were talking about your emails and the level, the extent to which you converse with each other. The thing to remember about public records is that the law pretty much puts everything under a big umbrella, if you will. Public records or files means any recorded data or information relating to the conduct of the public's business, prepared, owned, used, received, or retained by a public agency. or to which a public agency is entitled to receive a copy by law or contract, whether such data or information be handwritten, typed, tape recorded, videotaped, printed, photostated, photographed, or recorded by any other method. And then it goes on to say that anybody has a right to look at a public record. Anybody has the right to get a copy of a public record. So folks, think about that for a second. Everything that has to do with town business becomes a public record, and anybody can see it or anybody can get a copy of it. Well, why is that hard? Well, it's hard because on top of those base definitions, we have different exemptions and exclusions and exceptions. So there's some records that fall under an exemption, for instance, for personnel that would be an invasion of privacy, or records that would release would be a security risk. Or I mentioned before, the bids and the RFPs, or records that are part of legal strategy. The list is almost seems endless. Those of you who are on boards of ed, I don't know how many of you are on screen, nod your heads. If I say FERPA, you know what I'm talking about, right? It's a federal law that says you can't release student educational records. The number of times that I've had to tell parents that those are records that you can't get because they're subject to FERPA, and they're not about your kid, they're about another kid. Their kid gets into a fight on the playground and they want to see the other kid's records. Well, you can't have them. And there's different federal laws and state statutes that take records off the book. So my advice is always to remember that everything starts as a public record, and don't automatically assume, don't get possessive. Don't say, well, they're mine, or they're my boards, or they can't possibly be public records. It would be too offensive to release those. I'll just give you an example of one exemption. The exemption for invasion of privacy. A lot of times people ask for personnel records. And the question is, they work for the public, why can't I have them? Well, there's an invasion of privacy standard. It was set back in 1993 in a case called the Perkins decision. Perkins was a teacher who objected to the release of her attendance records. And the matter went all the way to the state Supreme Court, and the Supreme Court said, no, wait a minute. The attendance records of all of us who work in the public sector are public records, period, end of story. And to have been an invasion of her privacy, the release of those records would have to have been both highly offensive and not a matter of public concern. So highly offensive, not a matter of public concern. And then you say, well, wait a minute, how does that work? Well, how it works is you work in a public office and someone wants to see your personnel records. The person in charge, the HR person, looks at it and says, would releasing this be highly offensive and not a matter of public concern? And if the person believes that it would, they go to the employee or the individual and say, hey, we think it's an invasion of your privacy. What do you think? And if the individual doesn't care, then out they go. But if the individual says, yeah, that's right, we agree, it meets that standard, then the process stops. The records can't be released until the person files a complaint with the FOI commission. The commission looks at the records and says, no, you know what? Sorry, town, you're wrong. Give the records out. Highly offensive, not a matter of public concern. What does that mean? I'm going to give you one story, one example to show you how that works. City of Middletown had a situation where a police officer was rumored to be having all kinds of difficulties at home, all kinds of problems. The rumors got so loud that they took him off the street and they put him on desk duty. They did an internal affairs investigation. They finished it and they decided, you know what, the guy's having a lot of trouble at home, but he's doing a good job as a police officer. We're going to put him back on the street. So they put him back on the street, and the Hartford Courant hears about it, and they immediately want to see a copy of that IA report. They ask for the IA report. Middletown PD looks at it and says, there's a lot about this guy's home life in here. I don't really think we should give it out. It's highly offensive, and the public doesn't need to know. The guy agrees. They refuse. The Courant, as is its right, files a complaint with the FOI commission. The Courant files a complaint. We're unable to resolve it. By the way, if you're ever involved in a complaint, some of you have been, we always try to resolve it. We try to mediate it so that you don't have to go to a hearing. But that failed. It goes to a hearing, and the hearing officer looks at the records in camera behind closed doors. Nobody else sees them and says, there's a long list of this guy's home life problems in here. And we don't think that's a matter of public concern, and we think it would be offensive. And by the way, all the public needs to know is he's doing a good job. That's why he's back on the street. It meets both prongs, complaint dismissed. But the key is meeting both prongs. Just one example, folks, of how difficult sometimes the records provisions are. A lot of times the requests for things in personnel files are highly offensive. It's because it's situations where someone's done something wrong. They want to see what code he or she has violated, why he's been suspended or fined or something like that. But then it doesn't meet that second. People have a right to know if somebody on the public payroll has done something wrong, and so the record's usually ordered released. There are numerous exemptions and exceptions. If you have any interactions with the records provisions, by all means, look at them or call and ask. We're happy to try to help. But that's just like one example of, the records provisions and how tricky they can be. I'm taking one last look at there was one thing, I got to be honest with you, one thing that I saw in the questions that came, and this idea that somehow FOI restricts your ability to do work. Well, I understand that sentiment, but you have to remember that you're doing the public's work. And this idea of doing work, on the fly behind closed doors and not letting the public in creates all kinds of problems. It leads to multiple FOI situations where, John Rowland's term as a governor was ultimately done in by FOI request. Joe Ganem in Bridgeport. I know that none of you are, walking down those paths, but you have to remember that doing your work in public is key if you're going to if you're going to be on a board or commission. Again, mindful of the time, we've been at it about an hour. Are there any questions, anything that I didn't answer that you want to ask? Now's the time. Anybody just want to jump right in or unmute or send a chat? I see Cheryl, go ahead.
Hi. Yeah, I have a question about the implications of two board members maybe talking about an application or a matter outside of a meeting. In other words, somebody calls somebody else up in the middle of in between meetings and says, hey, what do you think about this? So can you talk about that a little bit?
Is that a land use situation, Cheryl?
Yes.
Yeah, that's a problem, but it's not necessarily an FOI problem. There's something called ex parte communication. Again, I'm out of my league a little bit here, but when it comes to a pending application, if board members talk about it, it becomes a legal matter on the land use side. From an FOI standpoint, the two of them having the conversation only really becomes a problem if that they constitute a quorum of the board or if they're a designated subcommittee and they haven't noticed the meeting. But a private conversation like that is more often a problem. And you'll hear the lawyers toss around the phrase ex parte communication. That's a serious no-no, but it's ground for being sued, not for an FOI complaint.
Tom, there was another question in chat.
Sure.
What is the use of Google Drive okay if it's publicly viewable?
I mean, Google Drive, I'm assuming this means you put a document in the record and everybody gets to play with it, that kind of thing, work on it. I mean, there are some that say that that's a meeting. I would argue that if it's publicly visible and it's clear that it's there, the different iterations are available. You're probably okay, but the key is that when the final version is put together, that it's done so at a meeting.
Then there was, I guess, sort of a related question. If you share a document on your screen during a virtual meeting, should that document be included in the minutes?
Yes, in the minutes, not necessarily. It becomes a public record that everybody has a right to see. But once it's out there at a meeting, it should be available for anybody who likes to see it.
And is that in hard copy? Like, obviously, if a meeting is virtual and it's recorded, that the time in which that document on a shared screen is up is part of the recording.
Right. But I would also argue that it should be available at least for printing if somebody wants a copy.
Okay.
Let me go back to one other thing about records. Remember what I said, be careful your use of your personal devices. Just remember that when you create something in the conduct of town business, it becomes a public record. All too often, people sort of lose sight of that. it happens less with board members like yourselves than it does with the, town officials or town employees, and they trade sort of stories or jokes or things like that. You just want to always make sure that you think, do I want to see this on the front page of the Hartford Courant? If you don't send it. That's the strongest advice. I'm going to share one other little story before we close, just to show you that, we preach this, but some people, even people who should know, don't. This is a situation. We had a law department in one of our major cities was looking for a senior legal secretary. I'm reading the application. This was during the real height of the pandemic, where everybody was locked in and everything was being done virtually. And I know that I recognize that was hard and all that. But during the height of all this, the head of the law department sends the following email to a colleague. I want you to listen carefully. I would like you soon to reach out to a woman who had applied on behalf of the law department to thank her for her interest in the position and to inform her that we went in another direction. I feel that you have the most experience in our office handling these types of discussions. He pauses for effect. After many years of breaking off relationships with your past girlfriends and flings. Did he really send that? Did he really send that through the law department? Well, yes, he did. He entitled this email, "Let Her Down Easy, Playboy." What are you doing? What are you doing? Now, folks, this is the head of a law department in a major city. So if he can do it, you can do it. Now, just one other thing, you're thinking, well, gee, Tom, why do you have that? Because he sent this to his colleague while the colleague was conducting a deposition in an open virtual courtroom, and the whole courtroom saw it. Think before you write, please, and think before you send. Understand that it becomes a public record if it has to do with official business. On that note, are there any other questions? Is there anything else you guys want to ask about?
Tom, I've got a few that I'm not sure we hit.
Okay.
If an agenda is filed late or not at all, and the board meets anyway, does that meeting count? Are their decisions still valid?
Right. So Sherry, we are not the FOI FBI. If you call me and tell me about that, I'm not running out there with handcuffs. So the meeting stands, but if somebody files a complaint, our commission could say that meeting is null and void. We could wipe out the whole thing.
Okay.
So you're really running the risk. You're running the risk of having an improper meeting. My advice when that happens, when the agenda is late or something like that, is at the next meeting to ratify every vote that was taken. Don't go back for the whole discussion, but say, look, folks, we screwed up. These items we voted on, I need another vote, and have them officially voted on at another meeting that's properly noticed. And that should cover it.
We've had it happen, I think, with the Board of Finance, and our concern was that decisions were made that were money decisions, and we wanted to make sure that they were covered and done properly. So they did go and ratify those votes at the next meeting.
That would be my advice, yes.
Okay. And another quickie is, if a secretary misses a meeting, is it good enough for them to do the minutes from the recording?
Sure, just as long as there are minutes. Nothing in our law dictates who has to do those minutes.
Okay.
There was something in there, Sherry, about canceling meetings. There's nothing in the FOI Act. It's strange. We have all these rules about noticing meetings, but nothing about canceling it. So cancellation is really, do it as widely and as you can would be my advice, but there's nothing in the law that dictates how to do that.
Because you don't want to confuse people and lose them, right? It's your intention that you try to get them to the right place, the right time.
Correct.
Okay. The last thing I've got a note on here is for purposes of filing agendas and minutes, do you count holidays and weekends?
Okay. Minutes. The minutes of regular meetings are 7 calendar days. The minutes of special meetings are 7 business days. Don't ask me why they did it. So I always say, look to 7 days. And agendas, I would say the same. The town hall has to be open for that 24 hours. So you can't file it on a Friday night at 4 o'clock for a Monday 10 a.m. meeting. You got to have at least, you have to have at least 24 hours. So I would say, you know, for a 10 a.m. meeting on Monday morning, 10 a.m. Friday is 24 hours. 24 hours that would cover it.
Okay. And I think one thing that you might have missed was you have to file the record of votes within 48 hours. Is that correct?
It has to be available in 48 hours. It's not necessarily a formal document that you put on file anywhere. But I need to be able to find out within 48 hours what the votes were in a particular meeting. Some towns do a formal document, but it's not required.
Huh.
And it's got to be in writing in the somewhere in town what
Oh,
the
okay.
votes were. It's got to be in writing, but it's not something that you necessarily have to file away.
Okay.
Okay.
That's all I've got, sir.
All right.
There's one, Tom, there's one more question in chat.
Yes.
Which is a little bit, I think, more of a management question than a FOI question. But it's how do you deal with citizens that shout throughout meetings? Or if you have 3 minutes on citizens' comments and they go over that time and are very rude about stopping and moving on. How do you?
Well, John, that's what I was referring to, when I talked about the Zoom bombing. The same thing holds with an in-person meeting and also with public comment over Zoom. You have a right to shut them down. Now, obviously there's policy involved, and there's a lot of smaller towns, they're neighbors, they're friends, but you have a right to run an orderly meeting. And if you want them to sit down and they won't sit down and they're screaming and yelling, you can have them removed. I realize that's an extreme step, but you have a right to control the meeting.
Okay, that's all the questions in chat.
Right. Okay, guys. If that's it, thank you very much. Enjoy the rest of your evening. And if you have other questions, don't hesitate to pick up the phone and call. You will get an answer.
Thank you.
All right,
Thank you,
guys.
Tom. And
Thanks very much,
everybody,
Tom.
the recording will be available, and I'm also going to send out notes on tonight's meeting. I'll send them to all the participants who have given me their emails. Okay? All righty.
So long, guys.
Good night.
Good night.